Okay, folks. Well, it is another episode of Healthcare Unfiltered. And for those of you who listen to me, they know I'm fascinated by law. Although you probably know that I believe law is more about strategy than facts. We'll see if my current guest will agree with me, but I am really delighted to have Ron Chapman, Counsel Chapman, who would introduce himself in a little bit. We're going to talk about a topic that is really interesting. I titled this episode Defending Doctors, and we're going to go in a variety of ways with a little bit of focus into opioids. And sometimes are all the, how can you separate the signal from noise when it comes to physicians facing this situation? So,
Mhm.
Ron, welcome to Healthcare Unfiltered.
Thank you so much for having me. It's a pleasure to be here.
We're going to drop this doctor and counsel. Otherwise, we're going to be calling each other, titles. But
Yeah.
tell us a little bit about you, just, who you are and what kind of law you practice and what got you into law? Like, what made you decide to become a lawyer?
This is a really interesting story, and the person who was really at the helm of getting me into law just recently passed away. So I've been thinking about him a lot over the last couple of days here. I'm the product of two lawyers, which means naturally I didn't want to become a lawyer when I grew up. That's kind of how it is. You get that aversion to it. I decided that I was going to go in the military, and I went through officer training in the United States Marine Corps and was able to get selected as an officer. Part of that program has you go back to college to finish up college, and then you go back into the Marine Corps as an officer. Well, while I was there in college, and this was while Afghanistan and Iraq were both going on, I had a professor, his name was Mark Rigstad, and he taught me a class about the philosophy of war and peace. I was a philosophy major. And in that, we learned about the Geneva Convention, we learned about targeting of civilians and the ethical implications with that. And I did some study and I found out that that's what lawyers in the Marine Corps do. And I said, well, I think I might be able to do that. So I asked to switch my contract to law, went to law school, went out back into the Marine Corps. And then I found myself a few years later in Afghanistan advising military captains up to colonels about and even, kind of boots on the ground troops about who we were able to shoot and who we couldn't shoot, and then being there for actual like drone targeting decisions that were occurring in the Combat Operations Center, as well as doing investigations in the battle space. It was fascinating. I loved it. I prosecuted for a while. But when you work for the government, you either end up loving the government or you end up realizing that the little guy needs a defense too. And so I kind of realized that I might want to spend my time defending citizens as opposed to dealing with the government. So I came out into private practice, started working with my dad who had a healthcare practice, and I wanted to do criminal defense. I quickly realized when I came out into private practice that the area where law intersects with people's lives is healthcare. That's kind of the main area where law really intersects with our lives, especially government involvement with healthcare. And this was around the time that doctors were getting indicted in droves, and I was starting to realize that there was an impact on patients in the United States. And so I've been devoted to being in the middle of that conflict on the side of physicians and patients, trying to fight for good.
That's amazing. So, there's a couple of questions I have here, but when somebody comes to you as a physician, right? Uh,
Mhm.
and they're asking for your help to defend them. How much how much investigation do you need to do as a lawyer to be convinced that the physician is innocent and you want to defend, or you may find that the physician is guilty and you still want to defend in a way to get them the least possible punishment, I guess. In other words, do you have like, do you get a case where you say, I'm not defending this, you're guilty as F?
Yeah. Yeah. There's a billboard I just saw. I didn't see it live. I think I saw it on X, which I struggle calling it X. I still want to call it Twitter in my
I call
mind.
it Twitter, I don't care.
Yeah. So the billboard was a criminal defense attorney, and he said, even though you did it, you might not be guilty.
Right.
And I thought that was fantastic. So here's my position on all of that. I think those are all decisions that are better made by my client, right? So the investigation I do and the advice I provide, but the decision as to whether or not there's guilt, that really rests in the mind of the person. A lot of attorneys see it differently. A lot of attorneys decide that their client is guilty and then push them into a plea because they feel they will be convicted. I'm different than that. I think that everybody deserves um, the ability to go to a trial with an attorney who will defend them if that's what they choose and they know of the risks and accept them. Just like a surgery. If you're about to undergo a surgery, it might be very risky, but it may be necessary, and maybe those risks are acceptable. The person who makes that choice is never the surgeon. The surgeon can only advise on the risks and the potential benefits. And so when it comes to investigation, my efforts early on in a case, and that's why I wrote the book, Unraveling Federal Criminal Investigations, it talks a lot about this concept. My job is to provide my client as much information as possible so that they can make that informed decision about whether or not it's something that they should go to trial. So how do we do that? We have law and facts, and my job is really to help fuse those two things together. So what are the potential charges? And then what are the facts that we put in the bucket of each one of those charges? And then what is the probable outcome? I think unanimously, my clients ask me, what are my chances? My response is always, I will never answer that question based on the information that you provide me. I will only answer that question based on my own independent investigation when I have enough facts. And so that's really what I preach to all of the attorneys that work for me, as well as anybody else I lecture or come into contact with. You have to get as much information as early as possible. Hire the investigators, look through the medical records, look through the data, and get the work done so that you can provide your client real advice as opposed to speculation.
I'm glad you mentioned the book because I did not finish reading it. I have it. I'm halfway through. I loved it, and I want to make sure that listeners and viewers know about it, and we'll
Thank
get
you so
into it.
much.
But I have to ask you before I mention the book. In healthcare law, how subspecialized is that? Like, in other words, there are hospitals, there's the American Medical Association,
Mhm.
there's like so many things going on.
Mhm.
Is there a specific segment from healthcare that you focus on, or basically anything in healthcare?
My focus isn't on the specific entity that I'm defending, so I don't limit myself to long-term care facilities or just physicians. I will say, though, that I think I've represented probably more interventional pain physicians than anybody else in the country, and have gotten, I think, better results than anybody else in the country. Now, the reason why I've seen more of those types of clients is because they carry a lot of risk. They're doing interventional procedures, which are a high cost item for Medicare, which means you're already going to be relatively targeted there. And then as a result of the CDC guidelines, they are carrying the burden of prescribing the nation's pain medication because primary care physicians largely aren't doing it. So it's not that I've really only represented those folks. It's those are the clients that are usually seeking me out. That being said, pharmacies, long-term care facilities, home health care, hospice. I have run the full range, and my subject matter is healthcare fraud or controlled substance distribution against the DEA. I think I was born to be in a courtroom. I love doing it. I love representing clients. I'm waiting for a jury right now, so if we get a phone call, it may
Oh
have to go
boy, I love
down.
that. This is
Yeah,
this is oh boy.
yeah. I'm
This could happen
actually
live right here.
right here. The reason why my background is blurred is because I'm in a hotel room in Covington, Kentucky, which is right across from Cincinnati after a 3-week trial. And I appreciate you accommodating that trial
Hey,
schedule.
this never happens on Healthcare Unfiltered. We could have like a jury verdict live on Healthcare Unfiltered.
We could.
You
If the
know,
judge would let me have a camera in the courtroom, I certainly would do that for you.
Ron, when you do podcast, all we care about here now is clicks and likes. So this will get me more clicks. But going
Perfect.
back to your book, this is Ron wrote a great book, Fight the Feds, Unraveling Federal Criminal Investigations. So I want to get a little bit into this as we segue a little bit. So number one, I'm reading this book. First, I do like how you're trying to simplify the judicial system for me as a reader, because boy, it's very complex. I want to make sure you simplify it to listeners. You go into the courts, federal judges, appellate courts, like the district courts. I think there's a lot of things happening that people don't understand how it is. So if we can simplify this, will actually help us just understand how that works. Because from there, I want to tell you that I got the impression as I was reading that you really you're kind of you feel that the feds or the federal government is out to get people, the whether it is normal citizens or physicians, it is. And it struck me with this, and I was wondering, I want to try to understand the background, because it's very obvious as we read, like, I mean, okay, this guy, I want him to be my lawyer if I'm facing the feds. Like, I clearly want to be, I want to have my lawyer. But I felt there's something behind this. Like, why is it like right there? Like, it's like first 10 pages and he's right there against the feds.
Yep. No, you're absolutely right about that. So let me give you the background of that. And first, the name, kind of salacious, right? Fight the feds.
Right.
I'm not talking about a literal fight against the feds. We don't want insurrection or anything. But the way that we solve problems peacefully in our country is through our judicial system, whether it's civil or criminal. If the government has a problem with us, they charge somebody and we go to a trial. And so the fighting that we're referencing here is really just ensuring that you are able to put on your best defense. But let me highlight a couple of areas of that book for your listeners who may choose to pick up a copy that may be helpful in highlighting some of the strange things our government has done over the years. I don't know if you're at this chapter, but there's one called A Fishy Tale of Overcriminalization. And it's something that is actually coming up before the Supreme Court right now in this term, but was previously resolved. There's a case, United States versus Yates, and there's a few others. In these cases, there were laws basically saying that a fisherman can't keep a fish under a certain size. And so a fish inspector boards the boat in this Yates case and says, you have 9 fish, let's say, that are under a certain size. Go back to port and I'm going to fine you. And this is a federal inspector. Well, Yates decides to dump some of the fish overboard before he gets back. Doesn't sound like a very nice thing to do. I don't know why that happened. But what the government decided to do next was charge him with federal obstruction of justice, and then tampering with evidence, and I think even conspiracy related to it. And later in Supreme Court hearings, the justices were just a little bit concerned that that activity resulted in a potential jail sentence of 20 years, right? The original crime of catching undersized fish, I don't believe was actually punishable by any time in jail, but the destruction of the evidence carried a potential exposure by Congress of 20 years. And the statute that they used to charge Mr. Yates, this was the fishy part of this story. It was the Sarbanes-Oxley Act. If anybody was old enough to remember Enron back in the early 2000s, it wasn't illegal when the feds were investigating you then for you to like back up a whole bunch of shredder trucks to your business and take documents out. And this is exactly what Enron did, and shred them. Well, when Sarbanes-Oxley came out, this act, it prohibited the destruction of evidence when you're pending a federal investigation. And that's what made it a very serious offense. It was for Wall Street, right? It was for people who are engaged in big investigations. Well, they decided to use that against Mr. Yates until the Supreme Court heard the case and said, no, a fish is not a document. A fish is not something that was intended by Sarbanes-Oxley, government, get out of here. Now, that's great. Mr. Yates ended up doing okay. But let me tell you that there are thousands of Mr. Yateses all across the country who are facing aggressive application of statutes that were never intended to be used in the way that they're used. And federal prosecutors have almost unfettered decision-making or discretion to apply those statutes to just about anybody. There's I think a book, I can't remember the name of it. It's like a Harvey Glade book, 101 felonies a day or something like that. The argument is, or maybe 16 felonies a day. The argument is that every citizen is committing multiple felonies every day because of how broad and expansive these statutes are. So why is it this way? And I know I'm going long on this answer, but I'll wrap it up soon. Why is it this way? And the reason it's this way is because the goals of the government have sort of departed from the will of the people. We have a lot more bureaucratic crimes, a lot more crimes that are simply done against the state, as opposed to criminalizing things that harm the citizens of our country, which is really supposed to be the reason why we have a criminal law. It's a crime against society, not a crime against a bureaucrat. And that distance and that gap widens every day until we have now almost a complete system made up of bureaucratic crimes and many things that may not have actually caused harm to people in the United States.
Wow, that's really amazing. Um, it's I mean it is shocking to me after I listen to you. Well, not shocking. It is not no longer shocking to me after listening to your answer, the stats that you mentioned in the book.
Mm-hmm.
About 97% of people get the plea deal.
Mm-hmm.
And you claim, likely appropriately so, that part of this is because people get scared.
Oh, yeah. Yeah.
And they get nervous and they get worried and they feel like the little people. So when you're offered the plea deal, like, I'm going to take it and just get this over with because I move on. And what you're contesting, you're saying, you people are crazy. You need to have your day in court.
Absolutely. So one of the big reasons why these plea deals happen so much, I'll tell you the reason and the impact. The reason that the plea deals are occurring so much is because of those 20-year felony statutes. The government in the Yates case could have charged Mr. Yates with something that didn't involve jail time or a crime that involved 5 years of potential jail time. And he could have maybe gotten a sentence of probation. But instead, they reached for that 20-year crime. That happens to many defendants. If the government's going to charge you, they will stack 20-year sentence on top of 20-year sentence. And so the average defendant has to decide, am I going to roll the dice and face a potential lifelong sentence, or am I going to just give up? Instead of the more appropriate choice, am I going to roll the dice and face the appropriate sentence for the appropriate crime? That's the decision that defendants in this country should be allowed to make. Everything else is essentially a death sentence. The impact of all of that is when we have less trials, we have less appeals. When we have less trials, we have less judges who are experienced at hearing trials and deciding issues. When we have less trials, we have less development of the law. We have less Mr. Yateses going to the Supreme Court. And as that continues to happen, the trial right continues to erode. And so this thing that was a fundamental core of our democracy is slipping away as we know it before our eyes based on some of these laws. And that's really the tone that we seek to strike in the book.
I wanna move on just to a couple of things.
Yeah.
Number one is everybody knows that some trials are decided by a jury,
Mhm.
and some trials are not decided by a jury. So the first question is why? That's number one. And number two, I want to give you a non-lawyer perspective. I'm
Yeah.
not a lawyer. I'm fascinated by law, literally. Um, and I always wanted to be a lawyer. But the thing is, when it comes to a jury, the fear from people like me and everybody else who is not a lawyer, that maybe it's difficult, two things. Maybe it's difficult to explain to layman people who are not physicians, who are not in healthcare, the nuances of certain things, because you are being judged not by people of your peers, which
Yeah.
is the fundamental part of our judicial system, but you're judged by common citizens. So there's a fear there. That's number one I want to react to. And number two is there's a fear that depending on how the plaintiff or the prosecutor do, doctors are sometimes being painted in a different picture.
Yep.
They're making a lot of money, they're wealthy, they're greedy. I mean, you know how it is. Of
Yeah.
course, some of this could be true in the minority of cases. There's always bad apples in every profession.
Yep.
So there's a fear there that, to do this. So summarize my questions. Number one, when do we do it by jury versus no jury? On number two, can you relate to the fear that people are facing? And that's what might be leading to their pleas versus it's really the government pushing.
Well, yeah, I think it is mostly fear driven. I think that people, to answer the last question first, I think that the reason people will, in some cases, be coerced to plea and also coerced to cooperate against other people, which is a big part of the federal system, is fear-based. It's not necessarily just the government pushing, but that's the product of it. But to go back to the first question, in the federal system, which is what I do, and I can speak to that more than the state system, there's a strategy. You said, you mentioned strategy earlier, and there's a strategy that I employ when deciding whether to do a bench trial, which is just a judge, or a jury trial. And we have to look at two things, the law and the narrative, okay? And when the law surrounding the case is something that favors me, I have a high preference for a judge to make that decision because judges know the law better and juries often don't get it right. I have much respect for juries, all of them, but legal questions are intricate, and getting 12 people to agree on that is just really a tough thing to do. So we have narrative and law. If the narrative is something that is stacked against me from a jury standpoint, and the law is high in the case, meaning that it has larger legal implications, then I may be more likely to go for a judge if those two things are at issue. Now, if the narrative is something that I feel benefits me in front of a jury, and I'll give an example in a second, then I'm more likely to go for a jury. And if the legal issues are a little bit lower and less complex, or the legal defenses, I may go more for a jury. 99% of the time, I choose jury all the time because judges see, this is the one issue with judge trials, they see defendants day in and day out. They sentence 99% of the people that come in front of them with something and convict them. And finding an innocent person in that stack is a difficult thing to do. So what do I mean by narrative?
But as a defendant, you always have the right to a jury. Could the prosecutor deny you that?
In fact, both sides have to agree in the federal system. Good question. Both sides have to agree to go to a judge alone bench trial. In the case that I'm currently in, one of the defendants wanted a bench trial, and it was denied by the judge because the prosecutor didn't agree. So with the narrative, let's say I was representing, I talk about in the book, Timothy McVeigh. Let's say I was representing Timothy McVeigh, not a popular guy.
You started with Timothy McVeigh. I'm like, oh my God, he's starting right away with Timothy McVeigh.
Yeah, not a popular guy. And the reason why I talk about that case is because, Timothy McVeigh did what he did. But when we have situations where there's hysteria, when we have high profile situations where a lot of federal employees were killed in this bombing, you have a lot of anger. And in sometimes what you have are people taking matters into their own hands, vigilante justice. And that sort of happened in the McVeigh case, even though he was ultimately convicted and should have been. There were things that were done which shouldn't have been done. And I think that the government needs to be very careful about that. But if I was taking Timothy McVeigh to a trial in Oklahoma City in a courtroom that was steps away from the building that was bombed, I might be more likely to not go with a jury if one of my issues was an issue in the investigation, like a search and seizure problem. Like maybe the traffic stop of Timothy McVeigh as he was driving out of town was unlawful, and I wanted to take issue with that. I'm not going to go to a jury. That's legal. That is a bad narrative for me. Timothy McVeigh is going to be hated by anybody. The press is already on him. That's a judge situation. I believe that his case it ended up being handled in Colorado because of some of those issues eventually.
Yeah. So, so a lot of what's happening, not a, I mean, well, a lot actually. I mean, we've heard so much about the opioid crisis. I think as an oncologist myself,
Yeah.
who I recall being told how every pain I need to give OxyContin for. I mean, it was part of my training as a resident. It was crazy. But at the same time, there's a worry that the pendulum is just too much swinging in the wrong direction, where is there a possibility that pain not being treated properly? So have you been involved in the physicians prescribing narcotics and whether they are being accused by the government properly, justly? Like, what's your involvement in that space?
Yes, absolutely. That is the main area that I practice in. The jury that I'm waiting for right now is related to an interventional pain physician in Kentucky. He was charged with unlawfully prescribing opiates. I have dealt with cases down in Southern Ohio, the sort of origins of the quote unquote opiate epidemic. Portsmouth, Ohio was one of the epicenters. And for the last, I would say, 10 years, I've been consistently involved in those issues. I imagine in what you just told me as an oncologist, you probably came up during the pain is the fifth vital sign, J code.
Totally, totally. I can tell you, and I'll put this in my monologue. I mean, it was mid 90s.
Yeah.
And if I don't ask about the pain,
Mhm.
you'd be penalized. And
Yep.
it's actually on the board when you walk into the room of a patient.
Yep.
It's on the room. It was the fifth vital sign.
That's right.
And I mean, it was, yeah. I mean, it's hard for me to go back to 30 years ago. And
Yeah.
remember, did I overprescribe? I probably did. I was really pushed by hospital and administrators, and I was told this is the way to go. So,
Yeah.
absolutely correct. It was the fifth vital sign.
Yep, that's right. And the government often doesn't have a very good memory for what it's done to people in the past. Let me just take a second and kind of bring you full circle with some of the stuff that's going on here. And there's a couple of articles on my website that folks could read. One of them is really a history of the Controlled Substances Act. But just to go through it really quickly, we had something called the Harrison Narcotics Act, and what it was just a desire to tax controlled substance prescribing. And the IRS and whatnot were, well, at least the version of the IRS then were in control of ensuring that you had a tax stamp before prescribing. Then, we had the drug wave of the 60s, and we had Nixon involved in the Controlled Substances Act. And that's when the federal government decided to take ownership over all controlled substances. And they created a law that said you can't deal drugs, right? Well, there was this Dr. Moore, around that time, and he wasn't doing any evaluations or treatment. And the government said, well, he's a drug dealer. And Dr. Moore said, no, I'm a doctor. And the Supreme Court said, well, you're kind of a drug dealer, so go to jail. And that was the first time under the new act that a doctor was convicted. And what they said in that case was, if you prescribe outside the usual course of professional practice for other than a legitimate medical purpose, you can be guilty. Those words are really important because over time, the government has started to interpret those words in a way that has the DEA determining what is the practice of medicine and what is not. And that gets a little sticky because traditionally we have determined that states should be able to determine what is the practice of medicine in their state. For instance, the use of buprenorphine, an addiction medication, in some states is not permitted for pain, but it's FDA approved for pain. And so if you were to prescribe in that state, there could be an argument that you're not practicing medicine because it's not an approved use of the drug. This water gets a little bit more muddy when we have like the CDC come in and issue these guidelines, which prosecutors have then used as criteria required for a prescription. I just got out of a courtroom, and I can say this because this will probably air in a couple of weeks, so we'll have our decision already. But I just got out of a courtroom where the government was arguing that the failure to do pill counts or the failure to discharge a patient upon an inconsistent urine drug screen amounted to drug dealing. And the reality is, all of the literature in the practice of medicine, SAMHSA, ACIP, all of these entities, they all say you get to make a reasonable decision as a doctor, weighing the risks and the benefits of continued treatment. As an oncologist, you have a cancer patient who is suffering, and they show up with a little something in their system, maybe marijuana or something else. are you really ripping them off their pain medication? That is the most inhumane thing you could ever do to a person who may be on death's doorstep. And that's the tragedy of the situation. So, by defending and holding the line on this issue and fighting these cases, I do believe that I am working on behalf of pain patients in the United States to ensure that they have access.
Do you ever recommend a plea deal to your clients? I mean, I can obviously I can tell that you believe in people should have their day in court. But have you ever had a situation where you said, you know what, let's take the plea deal?
Absolutely. And what I say to my clients is my job pre-trial is to get you a proposal for the best deal possible, and I want to make your decision as hard as possible. Let's say there's a client where they're facing, massive charges, drug conspiracy and all of this stuff. And I'm able to negotiate with the government and give them, bring to my client something like a low-level felony or even a misdemeanor. That may be something that we want to avoid risk on, and we may want to accept that deal. And so I fight to get them the best thing that I can bring to them from the government in terms of an offer, and they get to decide whether or not they want to reject it. And sometimes I will say, I don't think we have the facts on our side. I think there's some issues here. And I think we should consider resolving the case. And in some cases, we've done that.
There is
Absolutely.
no question that opioids are overprescribed in certain situations. I mean, there's no question. I think that's a fact. Now, this does
Yeah.
not mean it's overprescribed all the time.
Mhm.
As a lawyer, how do you separate these two? Like, what type of investigation do you do? A doctor comes to you and he's being accused by unlawfully prescribing opioids. How long does it take you to understand what's going on, the type of investigation? Is there a process that you do, you and your teammates and your colleagues?
Yeah, there absolutely is. So let's go back to the phrase overprescribed, though. It's used a lot in these cases. And I think if we are talking about overprescribing, we shouldn't be talking about a federal felony drug offense. What we should really address, or what we should deal with there, is a state licensing complaint or taking away a DEA registration, which are civil matters and administrative matters. And so this is really the academic question here. If we have a physician who is loosely prescribing, what are the remedies? You can take away their registration, you can take away their license, you can sue them, you can get an injunction, or you can criminally charge them. Criminal charges, by law, really should be reserved for those who are not prescribing for a medical purpose. That's really where I draw the line. If I can tell a doctor is issuing a prescription for something that is non-medical and they know it, that might be sex for drugs or just for money, or they should really know that this patient isn't a legitimate patient, then I would absolutely consider that to be unlawful prescribing and over the top there. How you get there, it might have to be a repeated series of flagrant behavior before I say, okay, this is enough. I had a physician that I represented in Detroit. I won't say the name of the physician, but he was called the cough syrup king, I think the feds called him. And he was accused of prescribing more codeine with promethazine or promethazine with codeine than any doctor, I think, like in the state for the last 5 years. Accepted cash only. A lot of patient recruiters came into the practice. You're getting a lot closer there. And that's one that you may want to look at resolving. But many of these cases right now, they've shut down most of the pill mills. The Florida pill mills, Oxy 30s, flying out the door, robo signing prescriptions, those don't exist anymore. What exists now are practices who are seeking compliance plans and trying to do it the right way. And so it's kind of rare that we will see the old school version of a pill mill in the modern practice.
I think there are two areas when you take oncology aside, cancer patients or patients with cancer, just because oftentimes there's a clear, legit reason for the pain, but post-operative pain,
Mhm.
this is something where I believe sometimes things could be overprescribed.
Yep.
Um, Sometimes after tooth surgery, and sometimes
Yes.
it could be. So that is one thing I wanted to comment on, because I can tell you from personal experience, honestly, that some of my family members would have a minor operation and a discharge. I'm like, wow. I mean, I even actually get the prescription. I'm like, I can maybe get if absolutely needed, but I think let's start with ibuprofen. I mean, I think,
Yeah.
believe it or not, could work. So post-operative pain is an issue. Number two is the non-cancer pain, like, chronic lower back pain, things of that nature, where when you go into a physician, the physician, I mean, they're not going to really tell you you're lying. So I don't know from a physician perspective, chronic back pain. I mean, how do you even get to how do you know that the physician is doing this on purpose over prescribing versus really he meant well, he's trying to help a patient?
That is the hardest case. If I had somebody post-surgery acute care that a doctor started on medication and very quickly escalated the dose into a chronic dose, and there really weren't objective findings, that's a little easier to see that there's a problem there. But when a patient has been on, most of these patients aren't starting opiates for their first time. This case that I'm dealing with right now, every patient was referred by a primary care, and every patient had a workup, and every patient had objective findings on MRI. Now, MRIs can be tricky because, I have a bad MRI that might look terrible to some people. But if you match it with physical findings, then we've got somebody whose pain complaint can be addressed. And as long as we're rotating the drugs the way that we should and making sure that we stay away from things like hyperanalergia, and other complicated issues, I think we're doing a pretty good job. Here's where it comes down to it for me, and this is kind of stepping outside of the law, but I think we need to get back into, as a nation, understanding personal choice a little bit more. I ask juries during voir dire, which is the process of selecting a jury, I say, hey, have any of you on the jury made a decision for yourself that you just will not touch an opiate pain medication because of the risks? The reason why I ask that is to show the rest of the jury that a lot of people are capable of making that personal choice and staying away from it. And if a doctor gives you a prescription that you don't feel you want to take, talking about your treatment options is something that you can certainly do with your physician, right? And I really would hope that as we're looking at doctors who choose to prescribe, we aren't ignoring the fact that on the other side of that is an individual who is complaining of what they believe to be a legitimate medical issue, seeking treatment from a healthcare provider, and making the individual choice to receive that medication. That is the majority reason why that physician chooses to prescribe. And instead, what I see prosecutors doing is looking at these patients more like they're victims. And in some cases, they may be for a very dirty doctor. But we need to factor in that personal choice. To really fully answer the question, I really look at the information the physician is obtaining, and I look at whether or not that information is obtained in good faith, or if it appears to be just papering the file to make it look as if, there was good prescribing, but there really wasn't. That's really where it comes down to it for me.
I mean, an example, I did, probably this is the fifth or sixth episode I do on opioids, but one of the episodes I did was with Dr. Jay Joshi,
Oh, yeah.
who wrote a book on his experience. I don't know if you represented him or not, but basically, if you read his book, some of the things that happened, I mean, he strongly believed he was accused wrongly, and he did serve time, and he wrote a book on this, but he did plea. And in reading the book, he paints the picture. It was really tough decision for him, but he just felt he had to because he wanted to move on. I don't know how much you know about this case, but can we use this as an example into how you'd have handled this?
Yeah, sure. First, I normally can't disclose who I've represented, but I can disclose who I didn't represent, and I wasn't personally involved in that case. I can tell you that. But that being said, I am relatively familiar. I know Jay. He's a wonderful person, and a fantastic educator. And I think that I think the world of him. I think he
Yeah,
does.
and the only reason I mentioned because he went public with a book and he
Yeah,
wrote this
that's right.
story. So otherwise, certainly everything is confidential, but he clearly put a lot of things publicly in a book,
Yep.
and that's why I felt comfortable asking about that.
No, absolutely, certainly on point, and I think he would enjoy that we're having a bit of a discussion about that. I will say that when it comes down to it, the personal choice to accept a plea deal is one based on access to counsel and a good defense. It's based on information related to your case, and it's based on exposure. It's really those three things, and that's unfortunately if you don't have that access to information or an attorney who understands your defense, you're not going to be able to make an effective choice. And the problem that I see in the legal field and in the defense arena for our country in general, Carl Sagan a long time ago talked about how the world was going to get so complicated that we're really just going to start falling into, he said, clutching our crystals and really superstition. I love that quote. I love that part of the book. I think that was maybe Cosmos. That makes a lot of sense to me in our current age. The number of federal statutes and regulations related to healthcare is likely in the hundreds of thousands. Violate any one of those, and you could be accused of a criminal offense. Um, then you're going to pick up the phone book and call the first federal criminal defense attorney that you can find who has the flashy web page, and he says, "I win" all over it, and say, "I'm a doc," and he will see dollar signs in his eyes because you probably make some money and you can pay a healthy retainer, and he really courts you. Has that person been ever in a criminal courtroom defending a doctor or understanding the practice of medicine? Do they know the experts? Would they know to contact a talented oncologist like yourself to be involved in a case? Who knows, right? Who knows if they understand those regulations? That was the shortcoming that I found in the industry when I first arrived here. Healthcare is complicated, federal criminal law is complicated, but unfortunately, our federal criminal defense bar doesn't segregate itself into sections based on who we represent. You're a federal defense attorney, and that's it, right? We need, just like with tax law, a core of federal defense attorneys who also understand medicine, more MD JDs, more people. I went and got a master's in healthcare law, more people who do that. And there's several people at my firm who have that as well. It's a requirement because when we stand up in a courtroom and we represent a client, we know the local coverage determination for that case, or that code that we're defending. We know and memorize the CDC guidelines, the ACIP guidelines for prescribing pain medication. This isn't our first rodeo. That's what you need. And when you don't have that, and you're facing exposure and you're afraid your attorney doesn't get it, and you can't teach this 65-year-old person new tricks, you're going to have to make some tough decisions because that's what you got. And that's really tough. And I feel for those clients.
How important, Ron, the expert witnesses in your kind of trials when it comes to the opioids, and how do you come about finding them? How challenging that is,
Yeah.
and do you rely on them in the courtroom?
Absolutely. One of my very, very good friends, as well as an expert witness who works with me routinely, uh, Dr. Murphy. And I say good friend, I really mean, more of a colleague. We really discuss cases, and he's helped educate me on the medicine extensively. I've turned to him for a lot of these questions. Is this an appropriate use of gabapentin, or is this going to show up on a drug test? Great things. I routinely call him to the witness stand to provide his expertise. It's very important to have a solid expert in your corner. One problem that we have, though, is that doctors are generally a risk-averse population. And there's a lot of doctors when the DOJ calls who say, "Yes, I would love to be a DOJ expert. That will insulate me because I've worked for the DOJ and they've relied on my expertise." Because every pain doctor secretly fears that day that the government might come for them. But the opposite happens when a doctor stands up to testify against the government. A lot of physicians fear something happening to them. I will say, I've only heard of one, I think that was maybe Dr. Forrest Tennant, one expert witness for the defense ever having problems. That doesn't mean it's the only one. It's rare, but it's a fear on doctors' minds. And so it is hard to find people who are willing to raise their right hand in a case like this and defend a good doctor when it needs to be done.
But sometimes the prosecutors or the government, I don't know if this happens in your kind of cases, but they will paint the expert witness as someone who is doing this just for money. And they will ask, well, how much are you charging per hour? And how much are you charging per day? And how much you're charging for a deposition or a trial? And the poor jury, they're sitting there and hearing these numbers in the thousands and thousands. And it's hard. There's perception and reality. So if you're a juror, how do you really take that away? And the other question is, why do you lawyers go after this? Because you could do the same. You could ask their expert about their hourly rate as well and how much money they're making. So it's a wash. What's the point of going through this exercise?
The important part of going through this exercise is showing whether or not their testimony is really tied to their financial motivations in a case like this, right? So if I have an expert who happens to be paid a lot of money, that's really not going to be a factor for the jury if they find their testimony to be credible and believable, and if they're fair and balanced for both sides. But if I have one who works for only one side and the jury doesn't find their testimony to be the most credible, it's not going to be enough to lift their testimony into the credible realm. There's a well-known government expert named Timothy King. He just testified on the witness stand that he made over $2 million testifying for the government in about 30 cases that he's been involved in. He also doesn't practice medicine anymore. Well, he doesn't practice interventional pain anymore, which means you have largely an academic who is receiving 100% of their income from the federal government. Strange thing about that is juries don't seem to be too bothered when the federal government is paying somebody, but if they find that I have selected an expert and used them 7 or 8 times on the witness stand, that I have sort of like this inside track with a person who, like a puppet that I get to put on the stand and make them talk. So it is, it's not a level playing field when it comes to experts and compensation. But as a result of that, I think we try to find fair and balanced people who have worked for both sides. It's tough to do,
Well,
but
and no question you're going to do this. I guess what I don't, yeah, I mean, I see the lack of fairness. I just don't get because the experts are getting paid on both sides.
Yep.
So you could be very articulate in the courtroom and very convincing, and the same questions asked to your expert, you can reverse this. And if you're paying somebody 400 or 500 an hour and they're paying somebody 600, they're like, so let me hear again. I mean, you could do a lot of things. So, but do the judges sometimes say, you know what, guys, don't ask about compensation?
No, it's always on the table. I think it's a dance that we always have to do. Every expert knows it's coming. The exception is when there's an expert who I'm cross-examining who tries to get cute and claim that they don't remember what they made. This is always a fun moment. They're just like, I think some people think that they have protection in the phrase "I don't remember," and that's not the case, because there's ways around it. So recently I had an expert, I said, how much have you made from this case? And he wanted to be difficult. And he said, I don't remember. And I said, how many hours did you spend on the case? And he said, I'm not sure, but it was like over 50. And so we went through the hourly rate and all of that.
Right.
But then I calculated the number of pages that this expert would have had to review in order to make their opinion. It was probably something like 30,000 pages. And so I divided those 30,000 pages by the number of hours he gave me because he clearly shorted the money that he was talking about on his review. I'm giving my strategy away here. I hope no prosecutors are listening.
I think they probably know about this.
Yeah, they probably know about this. So I divided the number of pages and found out that he was spending like,
5
less
seconds.
than 2 seconds on each page. Yeah.
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 But is there a fair market value to this? Like, for example, right? I mean, if you're a juror and, whatever, like if somebody is getting paid fair market value, whatever that is, it's totally fine. Is there such a thing as a fair market value where, whatever that rate is, you can just simply look at the jury and say, this is really the fair market value. I mean, so it's not really, you're not really overpaying anyone.
Yeah, I think so. I think that if the government's expert and your expert are aligned and the amount of total compensation from one party or another doesn't seem to be egregious, there's an expert who made in the Purdue pharma litigation a few million from the government. That's probably not a good look. It doesn't look fair market. But if you get paid your customary 400, 500 an hour, and it's a big case, I don't think it's going to fault you. You know, the first case that my wife, Lauren, observed, she turned to me and she said, I had no idea that you could pay a witness to testify. It floored her, right? She just,
And you told her I pay him for his time, not to testify.
well, exactly. But the fact that she, saw this and came away with that impression, and she didn't have any legal knowledge or experience. She's a creative and in the art space. The fact that she came away with that impression was very, very interesting to me. And I was thinking, I thought that the expert was the the linchpin of my case, for lack of a better term. And now I'm realizing that that's not the case. They're a paid mouthpiece, and so really they're just kind of educating the jury on the medicine. And that's we should leave the convincing up to the witnesses and the education to the experts. And that's how I do it now, because regardless of whether or not you're getting paid, if you're teaching about what fluoroscopy is and a facet joint injection, that's the educating is much better than
Yeah. Yeah.
convincing, right?
Yeah. Well, before I ask you whatever else you would like to tell listeners and viewers about, I guess my last question is, are there any cases that you can, of course, without divulging anything confidential, like things that, cases you wish you never took and it was like too late, and I guess just an example of a case where someone calls you and you say, "This is I'm not the right lawyer for you."
Okay, so sort of a bad apple case. Well, generally speaking, the cases where I'm more likely to back out of or decline are not cases in which I've made a decision about whether or not the person is guilty. I will defend anybody because I believe everybody needs a defense. The cases where I have an issue are when the client is not providing truthful information related to the case. That's really the big thing for me, because the open and honest flow of communication, I don't care what you did, and it doesn't really change my defense because you still get to challenge the evidence that comes in. But the truthful information is important. So, I can give you sort of a vague example of a case from a long time ago where I had a client who didn't disclose to me that and this came out, I think in the record, didn't disclose to me that there may have been some modification to the records before they were produced to the government. Now, of course, as an attorney, I have an ethical obligation to ensure that when I present something into evidence, I believe that it's true and fair and accurate. And that lack of disclosure can really, really put you in hot water if it was later found out, because you don't, as an attorney, want to be accused of trying to falsify something before a court. And so, I found this out, and that caused a bit of an ethical dilemma. And I quickly realized that I was in a position where either I would have to put records into evidence that I knew were false, which is no question, I would not do that, right? Or I would have to hinder my client's defense by not being able to present medical records in the case. And I realized that that's the sort of ethical dilemma that requires an attorney to withdraw. Ethically, we should. Unfortunately, that has to now become somebody else's problem, and I don't know what they would have decided to do with it. But I know that I am now in a bind where either this person has to resolve the case if I'm going to be their counsel so that I'm not putting anything into evidence, or it's time for them to find somebody new and determine for themselves what they're willing to disclose to that person. And that's where you draw the line.
And then I just thought of another question I must ask you, because this comes a little bit from my experience in the Monsanto trials. I thought that lawyers spend a lot of time convincing the judge what they are allowed to put into evidence versus not.
Mm-hmm.
To me, this is the anti, I don't know, anti, whatever you call judicial fairness. Like
Yeah.
if I'm a juror,
Yeah.
show it all to me.
Yeah.
Don't decide what I need to see and what I can see.
Mm-hmm.
And so much arguments, and we can't put this, and then stipulate on certain things, and the judge has to rule in and strike this. But the point is, as a juror, I want to see it all. I want to see it all, and then I'll make my vote. And you guys spend so much time telling me what I need to see and what I can't see.
That's right. I see how that perspective could be shared by a juror, the sidebars and the whispering that
Right.
happens in the courtroom and the hidden picture because the jury just wants the information. And unfortunately, we're kind of trying to create a natural ecosystem in the courtroom, but we're doing it in a very unnatural kind of biodome way, like that Pauly Shore movie that probably should never have been made. Um, and I think the rules of evidence do a pretty good job of trying to create some rules for creating that ecosystem and allowing the story to naturally grow while ensuring that those kind of invasive predators don't get in there. That's really what we're trying to do. Let's just pick one rule and we'll talk about the hearsay rule, right? That's probably the most popular way that we would keep information out. And one of the reasons that we have that rule is because the defendant has a constitutional right to cross-examine those people who accuse them of a crime. What's accusing mean? Providing evidence of a crime. And so in this recent case, if the government wants to show that a death occurred and they want to introduce a death certificate, ordinarily they would have to call the coroner who signed the death certificate because that death certificate contains information that accuses somebody of a crime. If the government doesn't want to put on the coroner, put them on the witness stand, I can't cross-examine a piece of paper. And so I would object and say, that's hearsay, Judge. That statement on that paper is hearsay. Please bring the coroner. And so the government has a choice. A lot of the rules are really related to that, to make sure that the defendant's constitutional rights are protected. Otherwise, it doesn't get to be heard. So I would say that for the most part, the rules allow the relevant story to come in and prevent abuse of a defendant's constitutional rights. We're always bumping up against this information and rights. And judges have a tough, tough job in balancing that.
Ron, this has been amazing. I can honestly talk to you for hours. I love the
Same.
book, Fight the Feds, Unraveling Federal Criminal Investigations. This came out last year by Ronald W. Chapman. And unfortunately, we don't have a verdict while I have you, so I'm not going to get the clicks I was craving. But any last thoughts before I let you go, and you probably get some lunch before the jury comes back?
Before the jury, yeah, they've already been out for a day. I will, if it's a good verdict, I will update you and you can perhaps get it in there. Maybe we'll even shoot
Yes,
something before it
yes.
happens.
You
If
know,
it's,
they say the longer the jury stays, it's in your favor.
I hope so. This is a complicated case, 3 weeks of trial. If it's a bad verdict, I'm probably not going to tell you
No,
because
don't tell me. But it's a bad verdict. They would have come back by now. I think it's either a hung jury or it's
there
in
you
your
go.
favor. That's what I'm going to say.
I appreciate that. No, the only thing I will say is I started a little project called De Novo, which is a small audio only podcast where I just pull up some recent information of the day and chat about it. The next episode coming up will be related to a lot of the First Amendment litigation, ironically brought about by Larry Flint, who was that former publisher of Hustler, who was always in front of the Supreme Court launching First Amendment challenges and hoping to educate some people on the boundaries of the
Tell
First
us about
Amendment.
it again. Let's. I want to subscribe to it. So how do it's DE?
Yep, DENOVO. You may be able to find it on Spotify. It's a newer project, so hopefully you will be able to find it. I can email you a link.
Yes, please, please.
Have a
I
show
think
link.
a lot of people would like. Yeah. Well, congratulations and good luck with that. I think there's a lot of need, honestly, to like these legal type of podcasts for the folks who like this stuff. I mean, it's great.
It's similar to the book where we take cases and we put a little flavor on them so that people can have some fun while they're learning about why the world is the way it is and why the law is the way it is. And that's what I'm looking forward to presenting. But I've had it. It's great to have another conversation with a physician, especially when it relates to the law. I appreciate you having me on, and thank you so much for all of the wonderful, thoughtful questions.
Thank you, Ronald Chapman on Healthcare Unfiltered. Thanks so much.